You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. My name is Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This is episode 151, Patent Me Maybe, Carly Rae Jepsen-Style Patent Claims. I've had a lot of episodes about how to write patent claims. If you're new to the podcast, you'll want to go back and listen to those episodes. But briefly, the claims of a patent are what defines the boundaries of your invention. If you say you claim an invention having parts A, B, and C, but someone comes along and does something similar, but only has parts A and B, but not C, they're not infringing your patent and you can't stop them. So writing good patent claims is essential to getting the protection that you want. There are lots of ways to write patent claims. One way is called a Jepson-Style patent claim. It's not named after Carly Rae Jepsen, the singer with the 2011 hit song Call Me Maybe. It's named after an inventor named Jepsen from a patent case in 1917. The inventor's name is spelled differently than the singer, so it's not a typo in the podcast title. But I thought, what if I explained Jepson-Style patent claims as if Carly Rae Jepsen was trying to patent something based on her song Call Me Maybe? But before we go into the Carly Rae Jepsen style, let's first talk about the traditional way that U.S. patent claims are written. They're written more like a mystery novel. They hint at an innovation without revealing too much about what came before. The goal is to describe an invention as broadly as possible. Think of it like trying to patent a peanut butter and jelly sandwich before anyone had come up with peanut butter and jelly sandwich, but other kinds of sandwiches had existed before. A traditional U.S. patent claim for a peanut butter and jelly sandwich might read something like this: an edible product comprising a first bread slice, a second bread slice, and a mixture of peanut butter and jelly disposed between the first and second bread slices. Notice what this claim doesn't do. It doesn't admit that sandwiches existed before, and it doesn't specifically say what the innovation is. Now let's take a look how this might have been written if it was a Jepsen-style claim. A Jepsen-style claim is like a history lesson with a plot twist. It explicitly admits what's already known. A Jepsen-style patent claim for the same sandwich might read like this: a sandwich having a first bread slice and a second bread slice, the improvement comprising a mixture of peanut butter and jelly disposed between the first and second bread slices. You see the difference? The first half of the claim concedes that sandwiches already exist, and you're just saying what your improvement is. And it specifically says the improvement comprising. And it's the stuff that comes after the phrase that you're saying is the inventive part. This is why, at least in the United States, this is not a popular way to write patent claims. In the US, if you're writing patent claims like this, it's like you're giving up your Miranda rights. Anything you say can and will be used against you. In the US, you don't want to admit to anything about what your patent isn't. So you just say what your invention is, and it's up to the patent examiner to figure out if you should get a patent or not. It's not the inventor's job in the claims to spell out exactly what came before and what the improvement is. That's why most US patent attorneys prefer writing in the traditional claim style so they don't give up too much ground. In Europe, they actually use the style of Jepsen claims more often. Now, to see how this applies to Carly Rae Jepsen-inspired patent claims, let's take a look at two versions of a claim based on Call Me Maybe. The traditional claim keeps things broad and open-ended. For example, it might read like this: a method of getting your crush to fall in love with you comprising the steps of 1. Throwing a wish down a well, 2. Providing your phone number to a crush, 3. Asking the crush to call you maybe, 4. Answering your phone when the crush calls you, and 5. Setting up a date to meet the crush. The inventive part may just be throwing a wish down a well, just like the song says in the beginning. But in the traditional way the claims are written in the United States, this claim doesn't admit that giving out your number is old news, or asking someone to call you, or answering your phone, or setting up a date is old news. It's up to the examiner to find all the parts of the invention to say whether that's old news or not. That old news is called prior art in patent language. But if we were to write this as a Carly Rae Jepsen style claim, it would look a little bit different. In this format, we'd first acknowledge the prior art. That is, the fact that people have been giving out their numbers forever, asking someone to maybe give you a call, answering your phone, and setting up dates. You state that all up front as the stuff that's not innovative. Only then would you describe what makes this version innovative. So a Jepson-Style claim might read something like this: a method for getting your crush to fall in love with you, wherein the method includes providing your phone number to a crush, asking the crush to call you maybe, answering your phone when the crush calls you, and setting up a date to meet the crush, the improvement comprising throwing a wish down a well. This version admits that giving out your number isn't new, asking someone to maybe call you isn't new, admits that answering your phone isn't new, and admits that setting up a date isn't new, but claims that the real innovation is throwing a wish down a well. And we know that's what the inventor is saying the invention is because the claim specifically has the words the improvement comprising. It's only the stuff after the words, the improvement comprising, that the examiner has to look for as being inventive because you already admitted that the other stuff isn't new. Now, maybe you're thinking it doesn't matter how you write that because in the end, you'll only get a patent if the combination of everything is new and non-obvious. And you might be right in a lot of cases, but there might be complicated situations where it's not clear what the prior art actually disclosed and what it didn't. So why admit to anything that you don't have to? It's the American way. Don't admit to anything unless you're required to. Now, in real life, you probably wouldn't be able to get this patent claim either, but I'm just giving it as an easy example to understand the format differences between claim styles. And I know, this is crazy, but here's my number. So call me maybe at 424-281-0162 if you need assistance with your patents, trademarks, or other intellectual property. Until next time, I'm Adam Diament, and keep on inventing.
You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.